This honorable court is now in session.
Okay, and we apologize for the technical difficulties. Sometimes that's the way it works when you start trying to use technology. Sometimes it works, sometimes it doesn't.
I don't see the, by the way, I don't see the lawyers. Should I be seeing the lawyers?
They're there, I promise.
I mean, I've got little things on the end. I've got Angie and you and Judge McGee, and I've got maybe if I hit this, wait a minute. No.
You're probably in speaker view, Judge Golden. You need to find gallery view. Should be in the
I've got them now.
Okay.
I guess it's just because of the spacing here. I've got Miss Chastain and Mr. Crayer. I can see them. I'm good. Thank you.
All right. Want to go over just a couple of ground rules before we get started. First of all, I want to thank you for participating in this. I know that it's probably not the easiest thing to do always, and appreciate your clients agreeing to participate in this as well. Appreciate what Angie's done trying to make this work and what the AOC staff has done. We couldn't do it without them for sure. Most of you have been to the Court of Appeals before. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you need to let the court know what time you're requesting after you introduce yourself and before you begin your oral argument. Obviously, appellee gets no oral argument. If there are more than two parties to its side, you need to let the court also know how you're dividing your time. Before we get started, let me introduce the panel. It's Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. And Angie, unless there's something we need to take up, I'm ready for you to call the case, please.
Okay, in Re Jaylan J. et al.
Okay, let's hear from the appellants then.
Your Honor, before we proceed, if this is my first appearance before the court, if I could have asked Ms. Chastain to introduce me.
That would be fine. Yes, sir. You may proceed.
I'd like to introduce to the court Attorney David Crayer. This is his first appearance before the Court of Appeals. He practices in Shelby County and specifically in juvenile court on a regular basis. And he'll be presenting proof today on behalf of one of the appellants in this matter.
Certainly glad to have you, Mr. Crayer. Appreciate the introduction and hope to see you again.
Thank you, Your Honor.
Yes,
Again,
sir.
Your Honor, my name is David Crayer, and I am going to be dividing the time 50-50 between myself and Ms. Chastain for the appellants today, doing 7.5 minutes on my side. I am reserving 2 minutes for rebuttal, and we request, if I do conclude early, that any additional time be passed on to Ms. Chastain.
All right, you may proceed.
Your Honors, again, I'm appellant for the mother in this present case. We are here today to ask the court to decide whether the state has an obligation to investigate compliance with the permanency plan and whether the state's failure to conduct the investigation is grounds to overturn the termination of parental rights based on failure to prove the termination was in the best interest of the children, and the fact that the mother clearly made adjustments to her circumstances, conduct, and conditions so as to make it safe and in children's best interest to return to the mother. In the present case, we have an unrepresented mother and a family service worker who at best practices willful ignorance. The permanency plan itself required 5 tasks of the mother: housing, visitation, employment, support, and parenting assessment. Regarding housing, the FSW knew that the mother lived in 2 locations between March 2017 and the termination hearing, but could not recall whether he had ever asked for a copy of the lease and never conducted a home visit. With regard to visitation, the FSW knew visitation was occurring 3 to 4 times a month, but never attended visitation and denied he had proof of the visitation occurring. With employment, the FSW knew the visitation was occurring at the mother's place of employment, where she had worked during the entire duration of the proceedings, but could not recall ever asking for proof of employment. With child support, the mother had brought gifts to the children and had fed the children each time they came to visitation at her place of employment. And finally, regarding the parenting assessment, the FSW never contacted the mother's probation officer to find out what the terms of probation were, which included parenting classes, community service, moral recognition therapy, and anger management, all of which were completed back in 2013. Subsequent to the dependency and neglect that had occurred and her admission to the charges that she pled guilty to. All the certificates were available to my client because she had given them to the probation officer, but the FSW made no effort at all to either ask for, or didn't recall ever asking for the certificates, and made no effort to contact the probation officer. Further, the FSW admitted the mother and children had a bond, as was evident by his observation during court proceedings. So if we look at the best interest factors that are in this case, the first is whether the parent or guardian has made such an adjustment of circumstances of conduct. That is clearly something that has occurred in this case. The mother went above and beyond in complying with her probation terms, and in fact, bringing the kids in home and initiating the dependency and neglect modification to get the children back to her when they were dropped on her door by the previous custodian. Whether the parent or guardian had failed to effect a lasting adjustment to circumstances, clearly the adjustment had been made. Whether the parent or guardian has maintained regular visitation, again, it's undisputed. The visitation occurred 3 to 4 times a month. The phone calls were occurring 3 to 4 times a week for the mother to check on the children. This mother had a bond with these children. Whether a meaningful relationship had otherwise been established between the parent or guardian and the child, the FSW even admitted that there was a bond there. The effect of changing caretakers and the physical environment likely to have an impact on the emotional, psychological, and medical condition. The mother had a bond. It was a recurring, continuous bond with these children. Changes in circumstances returning them to her home would not have detrimentally impacted them and would leave these two children together, which was their expressed desired interest. Whether the parent or guardian or other person residing in the home had shown brutality, physical, sexual, emotional, or psychological abuse toward these children or another children, we can't dispute that at all. This case has an underlying allegation of the death of a sibling at the result of the hands of a paramour, and my client negligently failed to attain proper medical supervision, and we cannot dispute that at all. Whether the parent or guardian's mental health or emotional status would be detrimental to the child, that was not an issue at all. No proof was presented. And finally, the child support, whether it was consistent with child support guidelines, I will state there was never a child support order in this case. She did make some adjustments, but for somebody who's making $9.25 an hour and has another child at home that she's taking care of, she did not have a child support order. Your Honors, there are 2 prongs to the determination of whether to terminate an individual's parental rights: the legal grounds and best interest. And I know you know this well. We don't dispute the legal grounds, but argue that the state has not proven that it is in the best interest of the children that their mother's parental rights be terminated because of its willful ignorance and the FSW's failure to investigate. For these reasons, we argue that the mother has clearly made adjustments to her circumstances to make it in the best interest of the children to be returned to the home of the mother, and we ask that the termination of parental rights of the appellant mother be overturned and the children returned to her. Thank you for your time, Your Honor.
Thank you. Ms. Chastain?
Thank you, Your Honors. In this case, on behalf of Mr. Timothy Smith, my name is Autumn Chastain, and I represent Mr. Timothy Smith in this appeal. I did also represent Mr. Timothy Smith in some of the underlying proceedings, and I want to go through the timeline on some of the underlying proceedings because I think that they are relevant to the argument I'm going to ask the court to hear today. I'm not going to focus today on the arguments as they relate to the grounds for termination that were listed by the department. I think that Your Honors can read my argument on it and don't need to hear me go back over or read what I've already included in a brief. And same goes for the best interest analysis in this case. So I'd just ask your owners to read that portion. The part that I'd like to focus on today is on our ground that Timothy Smith's due process parental rights were violated. And given that the Department of Children's Services did not make any statutory allegations against Mr. Smith, he should have been given his child without this even proceeding to the point of dependency and neglect and or termination of his parental rights. And the reason that I state that is the procedural history of this case is that the children first were adjudicated dependent and neglected back in 2010. That original petition raised allegations against mother and did not raise any allegations against Mr. Smith as it related to his child.
And what was Mr. Smith's, I guess, legal position at that point in time?
Mr. Smith at that time was a putative father. He was not included in the proceedings in 2010. He was not appointed an attorney. He did not have representation in that proceeding or participate in that proceeding. All of the allegations in that dependency and neglect petition were regarding the incidents that occurred in mother's home at that time. Mr. Smith was...
Does the record indicate whether he was aware of those proceedings?
I do not believe that he was aware by actual notice.
Well, I don't, is there evidence in the record that he was aware of those proceedings?
Not that I am aware of.
Okay.
The court then found dependency and neglect in that case and ordered that the children be placed in the custody of the maternal grandmother. The evidence that's been presented in this case is that throughout that...
Let me ask you a question. What were his rights as the putative father at this point in time, and was the state aware of that?
Your Honor, the state was aware that he was putative father at the time. His name was included in the information and things at that time. So he was definitely identified. Mother gave information that he had visited and communicated with the children. I think even during the termination, there was evidence presented that father would travel. He lived in another state. He lived in Minnesota at the time, where he had lived for 15 years with his other children, worked and lived, and that he would travel here to visit the children, or the child. I say children because he took the other child as if his, though not biologically his. And he would, likewise, his family would take the child to visit him in Minnesota. So he maintained the relationship during that time. Even when grandmother had custody and mother was maintaining a supervised relationship with the child, father was not aware of that. And that's what he testified to during the termination.
So what do you say his rights were, and what do you say the duties of the state were at that point in time?
Your Honor, I believe that because he was identified as putative father, he was afforded the same rights as had he legitimated the child. He should have been notified, included, given the opportunity to have appointed counsel. And if there were allegations against him, then they should have been included in that petition so he would have opportunity. He should have been informed that he had a right to his child as biological father because his superior rights were intact and he was not.
Ms. Chastain?
Yes, Your Honor.
I'm sorry. In your brief, you state that Mr. Smith was contacted by the department and asked to come to Memphis upon them removing the children. Is there, and I believe you just said earlier that your client didn't have any notice of this. What is the proof in the record as to that situation? And was Mr. Smith able at that time to take custody of this child?
So there were two separate instances. In the 2010 instance, he was not party to the proceeding. In 2017, when mother had custody, of the child, where maternal grandmother dropped the children off with mother. Mother then went to the court and filed a petition to get custody. The court said, you're not supposed to have the children. So the department filed a petition, took the children into custody at that time, and that was March 7th, 2017. The department still did not contact father. Father's testimony was that on April 4th of 2017, upon traveling to visit the children, mother informed him that the children had been taken into custody. The representative from the department had also indicated that they did not notify him that the children had gone into custody or had him participate in that CFTM initially in 2017. He then participated in a CFTM April 5th, 2017. That new petition that the department filed in 2017 to bring the children into custody, again, did not raise any allegations about Mr. Smith. It did also name Mr. Smith as being the putative father of his child, Justin. But he was not aware that the child was taken into custody in March until mother notified him. He immediately participated in that first CFTM. He then relocated from Minnesota to Mississippi because the department told him and assigned a task that he needed to move closer because he said he wanted custody of his son. So he relocated here, which was to Mississippi, where his family was. The department then said he had to complete an ICPC, which the courts have been clear. If there are no allegations in a petition against a parent, then there should be no additional task, and the ICPC should not have been required, nor
Well,
should.
Ms. Chastain,
Yes, Your Honor.
the second part, I believe you've answered the first part of my question.
Right.
Just the second part of my question was Mr. Smith in a position to be able to take custody of his child at that time?
In 2017, yes, he said he wanted custody of his children, and he was told that he needed to relocate here.
All right, thank you.
Yes, Your
Thank you. And you've used your time, Ms. Chastain. We'll hear from the appellate.
Thank you, Your Honor. May it please the court, my name is Amber Seymour. I'm with the Attorney General's Office on behalf of the Department of Children's Services. The decision of the Shelby County Juvenile Court terminating both mother's and father's parental rights should be affirmed for two reasons. First, the grounds to terminate their rights was supported by clear and convincing evidence. And second, the termination of their rights was in the children's best interest. I'm going to start by discussing the termination as it relates to mother. Mother concedes on appeal that all of the grounds that were alleged and found by the trial court were indeed supported by the evidence. The department is not defending the abandonment grounds on appeal against either parent. So for mother, that leaves the grounds of severe child abuse, serving a more than 2-year sentence of incarceration for child abuse, and failing to manifest an ability and willingness to assume custody. To highlight just a few things for those grounds, the severe child abuse finding was based on the 2011 dependency and neglect proceedings, in which it was found that mother committed severe child abuse against the children's half sibling after her paramour, who was the father of Jaylan, put injuries on the half sibling that ultimately led to her death. And so mother had a severe child abuse finding of res judicata from that matter. That also led to her 2-year sentence on appeal. She pled guilty to attempted aggravated child abuse and received a 10-year sentence that she was serving on probation. And for the failure to manifest ground, as this court's aware, there are 2 prongs for that ground. The first is that the parent fails to manifest an ability and a willingness to assume custody or financial responsibility for the child. And the second is that there's a risk of substantial harm to the child. And this court's aware that there is a split on the proper interpretation of the first ground. There's the Aiden S interpretation and the Amon K interpretation. That issue is before the Supreme Court. Oral argument was held last week. The department filed a amicus brief in that case arguing for the Amon K approach, but that dispute does not need to be settled in order to affirm the ground in this case. Throughout the custodial episode, mother never provided proof of housing or income, nor did she provide proof of completing the parenting assessment. On pages 202 and 216 of the transcript, the department caseworker testified that he did ask mother for these documents, and she never provided them. So even at trial, the department still had no way to verify her income or that she completed this parenting assessment, which was particularly concerning considering mother's history of having a child die while in her care. So all of these factors led to the failure to manifest the ability and the willingness. They also led to the risk of substantial harm. The juvenile court took great concern that at the termination trial, mother still would not fully accept her responsibility in the death of that other child, and that also played into the risk of substantial harm should the children be returned to mother at that time. I would also like to note that the department was explicitly relieved of its obligation to provide reasonable efforts to reunify mother with the children after there was a severe child abuse finding. So the department did not have a duty to help mom work towards reunification. That is something that's provided by statute in 37-166G4A. So the department did not have a duty to help mother with this or to investigate as argued on appeal. For the best interest analysis as applied to mother, as this court's aware, there are 9 non-exhaustive statutory factors to consider, and I'm going to highlight just a few of those. Yes, mother did maintain visitation with the children, and yes, she had a meaningful relationship. But the other factors do weigh in favor of terminating her parental rights. Looking at factor 1, she did not make a change in circumstance, in that even at trial, she could not prove her income. She did not show that she had appropriate housing. She did not show that she completed a parenting assessment where we know it'd be safe to return the children to her. There was also the concern about her failure to accept her responsibility in the death of another child. Factor 6, she neglected a child in her care, with the half sibling of the children dying while in her care. And again, she didn't accept responsibility for that, even though she was serving a 10-year sentence on probation for attempted aggravated child abuse. I would also highlight factor 9, which is the failure to pay child support consistent with the guidelines. Mother testified that she was continuously employed, but she never made a single child support payment. At most, she provided some food to the children at visits and a couple of gifts, and that was not consistent with the income that she had. And then the duty to provide for child support was provided in the permanency plans. Factor 5, which is changing caretakers and the physical environment, that could likely have a negative impact on the children. These 2 children have really lacked permanency for a number of years now. They had been in the same pre-adoptive foster home for 2 years by trial. They were doing extremely well in that home. They were very bonded to one another. And Justin, who was old enough to testified that he wanted to be adopted by the foster mother if he could not live with mother or father. And the final factor that the juvenile court considered and gave significant weight to, which arguably kind of plays into that same factor 5, was Jaylan and Justin's bond to one another. And that was the most important factor for Justin, is to remain with Jaylan. And if that meant he couldn't live with the mother or father, he wanted to stay with Jaylan. And so all of these factors do weigh in favor of terminating mother's parental rights. Turning to father's issues, I will start with the due process argument, since that's what has been argued today. Father argues that he's entitled to relief in this termination case based on the alleged due process violations that occurred in prior dependency and neglect proceedings. As what has been discussed, there were 2 removals in this case, the first in 2010 following the death of the children's half-sibling, and then again in 2017 when it was learned that the children had been giving back to mother even though she was not supposed to have contact with them. So first, I would say that any issues relating to the underlying dependency and neglect proceedings are not properly before this court. This court does not have jurisdiction to relitigate those issues. Second, that argument, and that is whether any violations that occurred in those proceedings could affect this proceeding, has been waived for failure to raise it in the trial court. The trial court was denied an opportunity to hear that argument, make findings, and a ruling on that. And then finally, even if the argument hasn't been waived, this court has consistently held that a parent's due process violations in dependency and neglect proceedings are remedied by the procedural protections given in termination proceedings. This holding is also reflected in the case of In Re Aniston M, which is cited in both my brief and in the father's brief. In that case, a father was not granted relief in his termination appeal because of alleged due process errors in the dependency and neglect proceedings. The father's rights in that case were terminated for wanton disregard and based on the best interest analysis. And the court in that case held that neither of those findings relied on a prerequisite finding of dependency and neglect. And the same is true in this case. The ground for which father's rights were terminated was for substantial noncompliance. In making this holding, the juvenile court did not rely on the prior dependency and neglect proceedings. So whether or not there were or were not violations in those proceedings is irrelevant to this proceeding, because there has been no argument that he's been denied due process in this proceeding. He had notice, he had an opportunity to be heard. He has been denied no process in this case. So because the juvenile court did not rely on the dependency and neglect proceedings and instead focused on father's actions after the 2017 removal. So once the children were removed the second time and father was made aware of that, what he did or did not do after that period is what was relied upon. And so that was proper and did not deny father due process.
Let me ask you a question, because I want to make sure I understand what you're saying, that the argument has been waived. Are you saying the argument was waived in the dependent and neglect action, or it was waived in this particular action because it was not raised in the trial court?
The waiver argument relates to this specific action because there's nothing in the record in this case that shows that this argument has ever been made prior to the appeal.
It was made to this trial judge that there was a due process violation in the dependency and neglect action.
Right, that was never raised in the termination proceeding, correct, Your Honor. In
All
terms
right.
of the actual what was or wasn't raised in the dependency and neglect proceedings, it's really irrelevant because the court doesn't have jurisdiction to determine or relitigate any issues related to those proceedings. It's only the termination proceeding itself. So father does try to distinguish in the briefs his situation from the Aniston M case by arguing that had he been given custody of Justin either in 2010 or in 2017 when Justin is removed from mother, then the ground to terminate his rights would have never been established. But not only is that purely speculative, it also fails to take into account the fact that father was a putative father at that time. He was not a legal father. He did not have an order giving him any custodial rights to the child at that time. And there's nothing in the record suggesting that father petitioned the court to get custodial rights or otherwise try to obtain custody once it had been granted to the department. So turning to the ground in best interest for father, the ground of substantial noncompliance is what we have left for father after conceding the abandonment grounds for him. At the time that the initial termination petition was filed, his permanency plan responsibilities, including paying child support, maintaining housing and income and utilities, informing the department of the move that he planned to make to Mississippi to legitimate Justin and complete a parenting assessment. These requirements were reasonable and related to the conditions necessitating foster care. It's argued in the briefs that father should not have been subject to these plans as the child was not removed from his care and was removed from mother's care. However, the statute says that the requirements in the plan must be reasonable and related to the conditions necessitating foster care, not necessarily the removal itself. And so at the time that the removal happened in 2017, he was still just a putative father. He had not legitimated Justin. He did not have custodial rights from an order at that point. And his own testimony was that in the years preceding that, he had only seen Justin 4 times. And so it was reasonable for father to be required to legitimate Justin and begin forming a relationship with him through visitation and contact and otherwise establish that he had the ability and means to care for this child. So there was an initial termination petition filed in April of 2018. It was amended in December of that year. So at the time of the first petition, the only progress father had made at that point was completing the parenting assessment and then informing the department of his move to Mississippi. He had visited Justin some, but the caseworker's testimony was that the visitation was inconsistent and sporadic and not pre-planned. It was not the 4 hours per month that was provided for in the permanency plan. He also failed to legitimate Justin by that point. He waited until after the initial termination petition was filed. In the reply brief, father argues that his own testimony that he legitimated Justin in the summer of 2018 was blatantly false, relying on the amended birth certificate that was admitted into evidence. This birth certificate does have a May date stamped at the top of it. At least on the copy that I received from the court, that's all it is. It doesn't say who put that stamp there, so I can't tell if that was the juvenile court, if that was DCS, if that was someone in Mississippi, if it was a Department of Health. I don't know. To me, what I gleaned from the record is it's not clear. But even that dates after the initial termination petition was filed. And what is clear from the record is father's own testimony that he legitimated the child in the summer of 2018, and the caseworker's testimony that the caseworker got proof of that in 2019. But even giving father the benefit of the doubt in this situation and looking at the period beyond the original termination petition filing until that December of 2018, which is when it was amended, he was still in substantial noncompliance. Yes, he had legitimated Justin by that point, but his visitation went from being inconsistent to non-existent. From August to December of 2018, he never visited the child. He never paid child support. He still gave no proof of income or proof of housing. And so in either time period that we look at, father was in substantial noncompliance with the responsibilities in the permanency plan. And so for my last minute, I just want to briefly highlight some factors in the best interest analysis that apply to father. Factor 2, despite reasonable efforts by the department, he did not make a lasting adjustment to reunify with Justin. And in that, he did not provide proof of his housing or employment. He did not follow the court ordered timeline in the permanency plan for legitimating Justin, and he did not pay any child support. In factors 3 and 4, he did not maintain regular visitation with the child, and the court found that he also did not have a meaningful relationship with the child. Though his visits were initially occurring early in the custodial episode, they eventually stopped once he moved to Missouri to be with his girlfriend. When he lived in Mississippi, he was able to drive to Missouri nearly every weekend to visit with his girlfriend. But once he moved to Missouri, he would not make that drive back to Tennessee to visit with Justin. He would only come down for court hearings, and then once he was here, he would ask for visitation. And so based on these reasons and other factors that I discussed in my brief, I ask that the juvenile court's judgment be affirmed. Thank you.
Thank you. We'll now hear from the appellant in rebuttal. I believe you have 2 minutes each.
Thank you, Your Honor. With regard to failure to manifest, I would point out to the court that my client actually had their children dropped off on her door, at which point she took them into her care, got them registered for school, called the Department of Children's Services to conduct a home visit, filed a petition to get the child back, as well as everything that's previously been talked about regarding her probation to manifest change. But more importantly, the state actually argues in this current case that release of reasonable efforts is also a release to investigate when somebody comes in and says, I have done everything that I'm supposed to do. I have made changes. I would like my children back from the Department of Children's Services. If you relieve the Department of Children's Services of investigating whether or not somebody's in compliance, and once you have done is given them the right to terminate parental rights at the time at the determination of dependency and neglect, because then they don't have to investigate. They can just go to termination and say, Your Honor, they've never done anything. They haven't proved anything. And for an individual who doesn't have an attorney, who comes in and says, I've done anything, which is what's going on here, and what would go on in any case where the children were removed, but not retained in the Department of Children's Services custody, then there's nobody reminding them to say, hey, can you at least ask for the documentation? Can you at least conduct a home visit? Can you at least contact the probation officer to find out what the obligations are? Mother didn't know that that's what she had needed to do. She just came in and said, hey, I have done everything. I'm in compliance. I'm trying to get my kids back who were abandoned basically by the previous custodian because she went into jail. And so I would ask the court to take that into consideration in making its determination. Thank you.
Thank you. Ms. Chastain?
Thank you, Your Honor. Your Honor, in response to counsel's statement that the issue is waived at the termination, I'd submit that the record does show that in the underlying dependency and neglect that was filed back in March of 2017, the testimony was that father participated in every permanency plan hearing and every meeting that the department had. He also participated in the court matters. However, despite a permanency plan being entered in April of 2017 and a modification in April of 2018, and the department filing a TPR in April of 2018, Mr. Smith was never appointed counsel. I was not appointed in this matter until June 7th of 2018. So he was not afforded his right to counsel or informed that he could assert his superior rights and have the assistance of making the department provide the assistance and things they needed. Although what I submit to your honors, the permanency plan is never needed. I did raise that objection at the dependency and neglect. I specifically raised the point that in the petition for dependency and neglect, that there were no allegations against him, that in the underlying from 2010, he was not a party and participated in that. He was never afforded an attorney. There were never allegations in 2010 or 2017 for which he could defend. There were no findings against him in the petition or in the order. There was no notice to him of entry of the order, changing custody, and he never voluntarily relinquished his superior rights. And so he retained those because there was no superior risk. We filed an appeal on that DNN, which was still pending at the time the TPR was filed. We asked to stay the TPR until the appeal of the DNN on that issue, and that was denied. So I do not believe it is waived in this TPR consideration, for your honor.
All right. Thank you, counsel. We appreciate your arguments. We'll try to get you an opinion at the earliest possible day. Again, we appreciate you participating in this as well as your clients. Ms. Angie, let's recess to the call of the case this afternoon.
This court is in recess until 1 p.m.
Thank you.
Thank you, Your Honors.
Your honors.